Okay, next case on the docket is case number 18-1835, Arnold Lewis Jones versus CIGNA Health and Life Insurance Company and CIGNA Health Management, Inc. Okay, you want 5 minutes for rebuttal, sir?
Yes, Your Honor.
Okay.
Good morning, Your Honors. My name is Dave Garwitz. I represent Mr. Lewis Jones at the trial level as well as at the appellate level. May it please the court, what the defense is attempting to do in this case is essentially apply an ERISA standard to a Florida state contract. And as I tried to make clear to Judge Roberts, there's a huge difference between an ERISA case where there is a fiduciary relationship between the administrators, the membership, and so forth. They are supposed to do, theoretically, what is in the best interests of the members of the plan so that they can get the attention and the medical coverage that was anticipated by the medical plan. This Florida insurance contract is not ERISA. It is by a for-profit company whose only obligation to the insureds under their insurance policies is a contractual legal obligation. And if they are going to be limited only by the contractual limitations of the policy, there has to be mutuality. And what CIGNA has obviously done in this case is they're coming in and saying, well, we're only going to provide the coverage if we want to. And they've done it by, in this particular case, if a reasonable person reviewed the exclusion that they're relying on, there are 4 categories in that exclusion, and all of those categories very clearly and obviously refer only to novel experimental treatment. And if somebody goes to their doctor and says, well, you know, we have this treatment that hasn't been really tried very often.
Let me ask you, are you, I mean, it seems like the threshold here is they're saying this covers up, this is excluded under the policy, and they cite to the, I think it's record 1844, the policies there at that part of the record, and they're saying, okay, these things are excluded if it's some type of procedure that's experimental, investigational, or unproven services. So we have to address whether that's ambiguous or not, and then it defines what experimental and investigational and unproven services to mean, and it talks about it not being demonstrated through existing peer-reviewed evidence-based scientific literature to be safe and effective for treating the condition that Mr. Lewis has.
Right.
So step one, how is that ambiguous?
It's ambiguous because, well, first of all, it's not even applicable because there are clinical studies that demonstrate the.
Well, okay, but let's say there's 55 peer-reviewed studies that says this really does no good whatsoever, and one that says, yes, it can be helpful for the condition that your client has. I mean, this language of the contract also says to be determined by the utilization review physician. That's that Dr. P. I can't pronounce his last name.
Right. Well, first of all, with regard to the exclusion itself.
Yes, sir.
It does refer to, you have to look at in my opinion, as the Supreme Court says, you have to look at the totality of the language. In this case, the totality of the exclusion. It's referring to new treatments, not something that's been in use for decades of treatment. And so with regard to the issue of their determination, certainly somebody with an insurance company has to determine whether they're going to pay for a treatment or not, and it's great that they have a doctor who's determining that, but that does not mean that decision, that determination is entitled to any deference, and the court clearly gave deference to that decision because he found everybody's right. He didn't say our doctors were wrong, that there's no beneficial or successful treatment for fusions.
But I mean, he seems to be, that argument doesn't seem to be helpful to you, at least in my view. I mean, the judge here says, look, everybody's well-intentioned, everybody's qualified, these doctors, so I'm going to look at the research that's provided, And, he makes a finding in his final judgment that basically the bulk of the research, I'm using my own term now, suggests that this is not effective surgery for the condition that your fellow suffers.
With all due respect, I think he was persuaded by the defense that all he had to do was find their decision was reasonable. And the fact of the matter is that our argument is, and I think the literature is clear, that his decision was not reasonable.
I mean, but isn't the judge saying in his judgment, saying, okay, look, each doctor has their own view. There is language in this policy that requires a certain methodology as to whether a treatment or a surgery is approved or not. The information, the peer review information suggests to me that it's not safe or effective, and he talks about that the decision of Dr. P is not arbitrary and capricious as reasonable. Isn't contextually he's saying, just hang on, isn't contextually saying, look, as if your side came in with 47 peer-reviewed studies that says this is the best thing since sliced bread to treat this, and this Dr. P relies on some 1914 study that says this, we're going to deny coverage, that would be more arbitrary and unreasonable, and therefore there would be coverage. Isn't that kind of the thing?
I asked the judge specifically, are you finding this by the greater weight of the evidence? And he never said that. He was being honest. He's saying, I think there's evidence both ways, but I'm giving deference. I'm allowing what I think is a reasonable decision by this doctor to support. So specifically, I tried to see where the judge is coming from, and I asked him that question, and he didn't go there because he knew he was not finding it by the greater weight of the evidence. I think the record shows that he didn't find it by the greater weight of the evidence. He found it simply because he agreed with the defendant that the doctor only had to be reasonable. That's number one. And number two, if you look, and I didn't make this clear in my brief, but on page 2434 of the record, the defendant attached their own summaries to support their internal policies. And one of those summaries talks about degenerative disc disease without instability, shows a 65% success rate. So how is there any evidence anywhere in this record or in the studies because that's what it comes down to. What this doctor for the insurance company is saying, well, we don't think it's proven enough. But then you go into the ambiguity of the exclusion, and there's no parameters. How do you define success? How do you define effectiveness? How do you define consensus? And
to take that further, how do you define proven? If you have articles, peer-reviewed articles that are on one side versus the other, some say it's proven to treat that type of injury, some say it's not, then is it wrong for the trial judge just to say, you know what, it's not proven?
Because there are no studies that say it's unproven. The only thing the studies say is there might be alternative treatment that's just as good, which is not available under the policy, which is expensive, long-term cognitive therapy, which is not made available by this insurance company. That's number one. And number two, if you read the studies, none of them say it doesn't work. Every single study, and there are 4 major studies and then a bunch of minimal studies, every single study says that in certain situations, we think this, especially when everything else has been exhausted.
But he never did physical therapy. According to the record, if you're going to say he fits into the category of, and I'm not sure the right terms, but well-selected patients for surgery, after everything else has been exhausted.
He had 10 years of treatment, Your Honor, according to the record, with physical therapy.
Well, the physical...
Not years of physical therapy. He had minimal... He was required by this insurance company to get some physical therapy, psychological training and so forth before they would even approve it. Before they disapproved it to begin with, if you take a look at their statements, the record, first they said, well, you have to go do ABC. And he went to do ABC, including physical therapy, including stopping smoking, and then they disapproved him anyway.
Under subparagraph H in the order, the judge says this procedure is not generally accepted as,
Yes, it does. Yes, he does. He does say that, and there is not one shred of evidence in the record that supports that ruling. You cannot find anything in the record that shows that degenerative disc disease for a lack of diagnosed instability, because they say it isn't stable anyway at a microscopic level, is not generally approved. And in fact, when I cross-examined the defense doctor, Dr. P, because I can't pronounce his name, but when I cross-examined him, he said, well, yes, it is approved in certain areas, and the reality is it's approved everywhere in the country. Doctors all over this country have been they do 300,000 of these surgeries a year. And I think Medicare pays for 300,000, then there are another 300,000. You know, the bottom line is that nobody should run and have fusion surgery. And if this insurance company was really reasonable, they would say you need to exhaust every other possibility. And if they say you also need to exhaust cognitive therapy, then they need to provide it as an alternative. And if the court looks at the policy and looks at I have the name of the record here, but page 1836 in the record, they only approve for short-term therapy, which includes cognitive therapy, short-term, and then they limit what they're going to apply it for, and then they also play we may not provide it under these circumstances, including but not limited to. So first of all, they would not approve long-term cognitive therapy. And, you know, I think what really is upsetting about this case is, one, the court did apply an ERISA standard, which is not applicable. And if an insurance company has the discretion, basically to say we're not going to, how do you prove unproven in a case like this? You have to have a clear exclusion that delineates what's going to be excluded. If you are simply going to say, well, it's not demonstrated by the clinical studies, well, very high-level clinical studies do demonstrate the effectiveness. Some studies question the effectiveness and say you may be just as well off with cognitive therapy. That's second-level evidence, not first-level evidence. And then you have the issue of Medicare paying for this. So there is no basis in the law to allow the insurance company, to have discretion, deferential discretion.
What's the significance? You keep talking about Medicare pays for this. What's the significance vis-a-vis this case?
As I made clear in my brief, Medicare does not pay for unproven treatments. They make that's the statute. I cited the statute and the case law.
They use the exact same definition as the policy does?
Well, it's a longer statute, but they make reasoned decisions, and then the government goes by. But the reason that is very significant is, since this has been going on for decades, Medicare simply chooses to pay for it because, at least under certain circumstances, it works. I think really what is necessary here is you have competent doctors who do proper vetting of patients.
I mean, the exclusion says, okay, we're not going to pay for unproven services, and an unproven service is something determined by basically our utilization review physician, Dr. P, that's not been demonstrated through existing peer-reviewed scientific-based scientific literature to be safe and effective. So the contractual agreement that your client is running under says, I give this doctor the authority to determine, based upon this literature, whether this requested surgery is safe and effective. And that doctor then gets that request from you, your side, and looks at the peer-reviewed information and makes a determination. And you don't like the determination, obviously, that's why you sued, and that's fair. And then it all goes in front of the judge on a DEC action, and the DEC action, there's evidence that comes in that says, here's all this peer-review information that I relied on, and we went through different levels with other doctors who did other, additional reviews under the policy, and we've determined that. And the trial judge then says, okay, based upon what you've provided to me, I think that it's an unambiguous term in the policy, and the evidence supports by the greater weight of the evidence, which is kind of, I mean, he was sort of
He refused
maybe
to say
not
that.
as clear about the burden of proof here, but I mean, he eventually said basically the greater weight of the evidence shows that this is not efficacious treatment here. And why is that not supported by the competent substantial evidence here?
With all due respect, he didn't say that, except with regard to the issue of the instability, saying that that is not generally accepted or proved. And again, all I can state is you will not find anything in the record, under any of the studies, under the defense attorney's or the defense doctor's testimony that supports that statement. There has to
So
be.
your argument now is there's not competent substantial evidence to support the judge's ruling?
I've relayed several arguments out in my brief. Number one, they should not be given deferential discretion because there's no mutuality of contract. Number two, there is no evidence supporting this decision. And number three, even if there was, the exclusion is clearly ambiguous because a reasonable person would not look at that exclusion and say, oh, gee, they may not pay for my fusion surgery. They would look at it and say, gee, they would think may not pay for my new treatment that just came down the pike because there's not enough behind it. Nobody, no reasonable person could possibly look at this exclusion and think to themselves, this is not going to cover surgery. And if they don't want to cover the fusion surgery, they should say so the insureds, like the city of Palm Bay or anybody else, can then decide we don't want to go with this policy of insurance. They didn't give the city that prerogative because they made the decision secretly.
You're in your rebuttal. You can keep
Thank you,
going.
Your Honor.
Oh, all right, thank you.
Sorry.
Yes, ma'am. Go ahead whenever you're ready.
Yes, let me just move this down. Sorry. May it please the court, Shari Gerson, and at council table, is Leslie Ann Marks on behalf of the appellee, CIGNA.
Okay.
So I think there needs to be some clarification at the onset in connection with the standard of review.
So you want to clear up the ambiguity?
There is no ambiguity, but there also is no such thing as an ERISA standard of review. Even under ERISA, there are varying standards of review: de novo, arbitrary and capricious, heightened arbitrary and capricious, etc. Here, it's clear that Judge Roberts applied the de novo standard of review, which is exactly what he said he was going to do at the beginning of trial. CIGNA requested at the beginning of trial that Judge Roberts apply an arbitrary and capricious standard, and he declined to do so. He said, I'm going to apply a greater weight of the evidence standard, and that's exactly what he did. As was pointed out already, if we look at paragraph H of the final judgments, Judge Roberts finds in the last sentence, the procedure is not generally accepted as efficacious.
Let me ask, I mean, the judgment was a little unclear if I'm looking at sub G here. I mean, basically, CIGNA's traveling under an exclusion, saying this is excluded from coverage. And then if I understand insurance law from back in the day when I used to actually do that, I mean, it's your burden to prove that the exclusion applies, right?
Yes, I would agree with that.
So this sub G is sort of, kind of, this would be a clearer judgment without subparagraph G, because they presented a claim, your side says excluded, you now had the burden of proof at trial as to why it's excluded, and that's what you put on evidence about that under the exclusion.
Well, I don't agree with that concept as a legal principle. However, I think that the judge found that plaintiff, who still has the burden to prove that it's covered in the first place, did not carry that burden either, and by a greater weight of the evidence did not show that it was covered under the policy.
What testimony was there that it wasn't medically, I mean, essentially he has to prove it's medically necessary to be covered. The exclusion is, then it's unsafe, unproven, and all the rest of that.
Right.
What testimony and evidence was there that it was not medically necessary?
I mean, I think they go hand in hand to a large degree, but I would definitely concede that the trial was defended on the exclusion by CIGNA. And I think if you look at Record 3271, the judge said in his oral ruling, CIGNA has shown by the greater weight of the evidence that the exclusion is not ambiguous and that it was properly applied.
Well, I mean, I agree. I mean, if you took G out of here, then the judgment would read more logically as to, okay, we all understand that the judge understood whose burden it was here regarding the exclusion, and then he had to analyze the evidence as the exclusion applied to the case.
I don't disagree that G probably makes it a little bit more difficult to decipher
Gummed
which
up the
standard.
works here a little bit.
I'm sorry?
Gummed up the works a little bit here.
Yeah, I think he might have, although I don't think it's really relevant for this panel to uphold the judge's ruling here, and that is because Judge Roberts did apply the standard he said he was going to apply, and what happened was he did not apply an arbitrary and capricious standard, and we know that because not only did he find that CIGNA's decision was correct, but he also did not give any deference to the medical director's decision, and that's very clear in paragraph H of the final judgment as well, the very first sentence. The court, in making this decision, does not give deference to the opinion of any of the physicians offered in this cause, which would include, and just everybody, it's Dr. Shabilsky is how Dr. P is pronounced.
Say it again?
Shabilsky.
Dr. P.
Exactly. I think I type his name Dr. P all the time because I don't even want to try to spell it. That's even more difficult than pronouncing it. And what happened here, just as Judge Roberts was tasked with doing, he found that the testimony of Dr. Shabilsky was more persuasive than the testimony of Dr. Keller that believed this surgery was going to help Mr. Jones. And we have to remember the exclusion is based on the peer-reviewed medical literature. And even Dr. Keller admitted, and Keller and Payne, frankly, but Dr. Keller specifically, and I was just going to give you the record site, I have it here, but Dr. Keller even said, I acknowledge there's disagreements in the medical literature, and it's record 1936 through 37. The fact that there's a disagreement in the medical community as to whether or not a multi-level lumbar fusion for multi-level degenerative disc disease without instability is effective supports the use of this exclusion under the policy. CIGNA doesn't have to disprove that it's effective, and I think that that's where the appellant is kind of getting confused here in some of the explanation and the arguments, and Dr. Shabilsky explained this at trial on cross-examination. He was asked about it. He said, well, isn't the fact that there's some literature that would support that it's effective show you that CIGNA has not shown that it's unproven? And Dr. Shabilsky explained, it's not that you don't have to disprove it. This is at 3181 through 82 of the record. And what Dr. Shabilsky says is, so the relevant question is not whether a study disproves that it's unproven. It's whether it's unproven. So what Dr. Shabilsky states is, for something to prove something can be very challenging with medical literature. And the closest thing we get to achieving proof is prospective randomized control trials showing clinically significant differences. And even in those circumstances, it doesn't necessarily prove it. The opposite of that is if you don't have that evidence or that evidence is conflicting, then in the medical community you consider it unproven. And that's what we're dealing with here. The medical literature does not prove that this procedure is effective for the condition that Mr. Jones suffers from.
The studies basically look like they showed it was no more effective than non-surgical treatment and carried a risk because of surgery. I don't recall any study, as plaintiff has argued, that said it's not effective, it's worthless, it's a waste of time. I think they basically kind of boiled down to either non-surgical treatment may be better, but I don't recall any study saying it's not effective at all. Am I wrong on that?
Well, I think it's that the studies don't support the safety and effectiveness of that it's efficacious for that procedure. It's no more helpful than other.
Right, but
like
no
you
more.
point
I
out,
mean, that
correct.
means if you take that as a standard that one treatment is no better than the other, then you can exclude both of them from coverage under that exclusion because neither one of them is proven the best. That's not how I read the exclusion. It certainly doesn't seem to be how Mr. Jones and his counsel reads it, that it's unproven to be effective at all, and none of these studies really say it's a waste of time. It may not be any better, it may not be as good, and if you get to the safety aspect, there are surgical risks, but...
Well, I think that you have to look at two things, and one is that it often doesn't work, and I think that a lot of the studies do support that. Furthermore, you also have to look at the length of the studies and how these clinical trials are, and one of the studies that the appellant relied upon at trial, the 2001 Volvo study, which is 2017 through 30, Fritzl was the author, in its argument to show that it did in fact support the use of it, which, by the way, it only showed that the people were 29% better after a short interval. But then in 2016, there was a later study by the same authors, and this was in record 3115 and 3116. And there they were doing a longer-term follow-up, and they were showing that there was no real difference. And so there was just not enough evidence to recommend a multi-level fusion without instability.
But that's the follow-up study even, it doesn't say it's ineffective, it just says it's no better than the other one. Doesn't it?
That there was no real difference as if they had never had the surgery.
So you're taking the position that often doesn't work is equated to unproven, is that right?
Well, based on the medical literature, I mean, I don't know if I would use that terminology, that it often doesn't work. I mean, that's why you have a medical director, somebody who has the medical training and background that's going to review the studies and determine whether or not the literature supports the use as described in the unambiguous exclusion in the policy, which is basically that it's not demonstrated through the peer-reviewed, evidence-based scientific literature to be safe and effective.
If the multi-level fusion is not approved, did the insurance company offer a treatment that would be, such as the cognitive therapy and ongoing physical therapy?
Well, that's really not how the process works. They don't say, okay, but try this. I mean, it's up to the physicians to request a procedure.
I understand that, but I mean, effectively, what Mr. Jones is left with, we don't approve this. Basically, we're not going to pay for any treatment, is what it almost comes across as. And I'm not sure that that's what's intended or if there was any follow-up, but that certainly, you can look at it that way and go, these things are just as good as each other. We're not going to let you have surgery, and you stop there.
There was absolutely nothing in the record to support that cognitive therapy had been denied by CIGNA. That wasn't the case, and the denial was not based on anything in connection with cognitive therapy, lack thereof, or evidence of. It was based exclusively on the lack of scientific evidence to support the use of this procedure. But there was no specific or separate request for cognitive therapy. That's in the record
Wouldn't it
here.
logically follow that you would deny it if it was presented? Because under these same studies, Dr. P could say, well, it doesn't, we don't have any scientific literature that says this is effective either.
The cognitive therapy, you're saying? I'm sorry.
Yes.
I don't believe that was what the literature supports. I mean, I don't think that was something that was presented to Dr. Shabilsky in connection with Mr. Jones's case, or any of the medical directors at CIGNA.
No, but the studies themselves, I mean, I think the Brock's study said the cognitive therapy was more effective. The other one seemed to say there was no real difference. And if there's no real difference, if one's not covered, then the other one wouldn't be covered either under the same logic.
Well, those are only two studies. I mean, I don't know what, before, there's nothing in the record that, let me rephrase that. CIGNA's policy on cognitive therapy, to the extent there's one that exists, is not part of the record here, so I don't have the benefit of that in front of me right now. So those are just, you mentioned two studies. Most of these medical coverage policies, as you've seen from the record, have multiple studies involved. And in fact, I wanted to make that point. Mr. Gorowitz stated that there's a study even that's listed and attached to the medical coverage policy that supports its use. And the point is that CIGNA does not cherry pick which studies it reviews in order to determine coverage for services. It reviews all the, all the available, and as it needs to, because it does say existing peer-reviewed literature, and it reviews everything, it takes everything into account to determine whether the requested service is proven for that particular diagnosis or condition.
So if there were 4 studies that says this multi-level fusion was very efficient, effective, and safe, and one study that said no, there's no difference one way or another, and Dr. P relied on the one study to decline coverage on behalf of CIGNA, you would have a different scenario, different case here, and it would be how would we be reviewing that ruling if Judge Roberts ruled in CIGNA's favor?
So I think that's a very difficult question for me to answer, but probably the best way for me to answer it is I don't know what those studies are and the quality of those studies, which Dr. Shabilsky testified to
I'll
at
help
trial.
you. They're all equally qualified. And
Right.
So now what happens?
I would have to hear the testimony by all the physicians that would be testifying at trial
I
before
mean,
I
you're
can answer that.
basically, if I'm understanding your case, cutting it away from ERISA and all this other stuff everybody's talking about, is your scientific literature was just much better than theirs. And therefore, when Dr. P said, you know, the scientific literature supports this, and that's why we're denying it, and Judge Roberts said, I'm not going to listen to the doctors because they're all well-intentioned and smart. I'm just going to look at the paperwork, and I just find it not to be effective. He used a fancier word, but it's not effective, and therefore coverage denied. That's what this case gets down to, isn't it?
I don't know if I would state it that way. I think that
Well, how do you see it?
I think that Judge Roberts did listen to the testimony of all three physicians that testified, 2 through deposition.
I'm not maligning Judge Roberts, but I mean,
Sure.
he made a statement, basically. I'm not giving deference to the opinions of anybody other than because they're all very qualified, trained, experienced, et cetera. And so he said, I'm going to look to the scientific literature, basically. Didn't he?
And he did, and I think, but what he meant by that, so again, this goes to the standard of review, that Judge Roberts was properly, as he said he would, apply a de novo standard, because under an arbitrary and capricious standard of review, the trial court does give deference to the decision of the plan administrator or the insurer. And so it's presumed that as long as there was a reasonable basis for the decision, it will be upheld. And there's a big distinction here. When you're looking at a case under an arbitrary and capricious standard, or potentially under an arbitrary and capricious standard of review, you first look to see if the decision by the insurer or the plan administrator under ERISA is de novo correct or de novo wrong. If it's de novo correct, that's it, the inquiry ends, which is what happened here. If it's de novo wrong, then you look to see, was the discretionary authority vested in the plan administrator, and if so, how was that discretion exercised? Here, while Judge Roberts does use the terms reasonable and discretion in his final judgment, it's really irrelevant because Judge Roberts had already found that CIGNA's decision was de novo correct. And there you don't need to look any further. And I just want to, because I'm running out of time, I just want to briefly address, if the panel would like to hear about the ambiguity. Judge Roberts got it right. He did not err in determining that the provision was unambiguous. As you can see, it's defined. It's stated who gets to make that determination. And under the sanctuary surgical case decided by the 11th Circuit, those were the factors that they looked at. And when they did that, they were distinguishing the Daltheimer's case cited by the plaintiff, where in that case, those things were lacking. And then it was found it's unambiguous, just, you know, it does define it clearly, and it states who's going to be making that decision. So if the panel has no further questions, I surrender the rest of my time and rest on our briefs.
Good, okay. All right,
thank
thank you,
you.
counsel.
One second.
Okay, Mr. Gorowitz, you have 3:53 in rebuttal.
Yes, Your Honor. Very quickly then. As the court noted, the judge did basically put the burden on the plaintiff, and instead of putting the burden on the defendant to prove its affirmative defense. This court really can do a de novo review of the medical literature. The studies are in the evidence, or the studies are in the record, and this court has the right to determine whether Judge Roberts was right or wrong, simply based on the evidence. And if the court is going to do that, look at the studies. None of the studies say it's unproven. With regard to that people are just as well off years later without having surgery, keep in mind that Mr. Jones exhausted what was available to him over 10 years of treatment, and nothing has happened, but he has gotten worse and worse and worse. And if we want to talk about proven, all you need to do is go to record 2434, lumbar fusion in the absence of instability, which the defendant submitted into evidence along with their internal coverage policy, and it talks about surgery leads to improvement in only 65% of cases. That's the insurance company's characterization, only 65% of cases. I would suggest that when somebody has reached the end of the line, when they've exhausted all other possibilities and all other treatments, then fusion is the next way to go. in your de novo review, you can define Judge Roberts was wrong and applied the wrong standard. And the fact of the matter is that there is no evidence in this record of unproven.
Well, I mean, the standard is, I think he got it right in a roundabout way and vis-a-vis whose burden of proof it was. I mean, he was talking in sub D, is there a reasonable basis for the decision to deny coverage? I mean, that CIGNA's decision, and he found that the procedure is not generally accepted as efficacious. I mean, he's kind of suggesting that, okay, and then in subparagraph I, fusion surgery, medical conditions is an excluded procedure. So he's talking about it comes under the exclusion. And, I grant you sub G probably shouldn't have been in there, but I mean, it seemed to me that he understood that they had to show what CIGNA had to show was excluded. And you're saying we have a de novo review, but I mean, there has to be competent substantial evidence for his determination. I mean, it's based upon the evidence presented, right?
There does have to be competent substantial
I mean,
evidence.
de novo is basically you're saying as a matter of law, this is a covered event.
Well, what I'm suggesting is in this case, since there's all the documentary evidence and in fact the studies, there's no reason Judge Roberts' decision should be given any greater weight than your own decision. If you decide, it's not like he's looking at testimony from the bench. He already said all the doctors are right. So if you are looking at only the studies, you can conclude Judge Roberts was wrong based on the evidence. You are as capable as anybody else of reading the studies and making a ruling as to what is reasonable in this particular case for Mr. Jones. And the problem I have, again, Your Honor, is it's a for-profit company. They do what's in their best interest if they can get away with it. And they have no fiduciary relationship, and that's why this whole argument about how ERISA should be a consideration in this case, which is still is essentially what they're saying, it shouldn't be considered. It should be by the contract that exclusion is ambiguous. What is effective? What is safe? How long does somebody have to go before we're going to approve surgery? 2 years, 3 years, 10 years? There are all kinds of problems. In addition, this could be a case of great public interest. I think that the court can embolden, by finding in favor of CIGNA, maybe this isn't your consideration, but you could be emboldening insurance companies to get more likely to deny treatments to people who need them in the future, and that could create problems.
Okay, counsel, your time's exhausted.
Thank you, Your Honors. I appreciated the opportunity.
Thank you.